why we, the people of Canada, should be the ones to make a constitution. Besides the obvious issues that brings into question constitutional changes, when Harper was leader of the opposition against the Liberals in power, he called Canada's government a benign dictatorship. That cancer grew under his rule. Constitutional lawyer Rocco Galati, who's speaking here at the Montreal Conference about the Bank of Canada lawsuit, calls Canada a quiet dictatorship, and how the courts are the only thing that stand between us and complete dictatorship.
And how they're separate, or how do they fit in with the Bank of Canada case. So unless I'm boring you, I'll take 5 to 7 minutes and I can just briefly talk about the bigger picture, if it's okay with you. All right, so Machiavelli once said that, you know, the people are most enslaved when they declare themselves to be free, right? That's certainly true here in North America. Ever since we got our Constitution patriated, although there was Quebec got screwed in the back rooms, people have declared themselves to be free through a Constitution, and people just, they've let down their vigilance, and people think they're free here. And it's a delusion. It's a complete delusion. We talk about constitutional democracy. And the way constitutional democracy is supposed to work is, Parliament makes the laws, the government, the executive enforces the laws. Obviously, again, they're geared at the citizens and institutions. And the courts, when there's a conflict, are supposed to, resolve those disputes. The courts, believe it or not, and this is a pathetic statement, for some who don't believe in the courts or lawyers, and there's good reason not to believe in the courts and lawyers, the courts are the only thing we have standing between the government, Parliament, and the citizen. So the courts decide two things. One, the relationship between the federal and provincial governments and institutions like the Senate and other constitutional institutions, and the state and the citizen. You remove the courts, what you have on a spectrum of benevolence to genocidal is simply a dictatorship. Call it what you want. It's a dictatorship. There's no two ways about it. And one of the really unfortunate aspects of recognizing or describing a dictatorship because of recent 20th century history is we have a tendency to confuse and equate a dictatorship with violence and peace with democracy. The United States of America, despite its problems, was probably the most vibrant democracy in the world in the 20th century, but they were also the most pathologically, sociologically violent society on the face of the earth. The two have nothing to do with each other. Canada, or places like some of the Nordic countries, were the most peaceful countries in the world, but they're dictatorial. I've been talking about a quiet dictatorship since the Crétin government. For me, it came down with a thump in April 2001 in Quebec City at the Summit of the Americas. That was the statement. You fuck off, you live in a dictatorship. Go home or we'll tear gas you. Okay? That was it. There were earlier signs, but because the people who were the victims of the action of the government didn't really get much attention. My Vancouver partners and I, mostly my Vancouver partners, I was in the background, defended the First Nations at Guffisson Lake. I don't know, who remembers Guffisson Lake? Very few. Lloyd Axworthy and Princess Diana of Wales were touring the world trying to convince the world that we should ban landmines, military landmines. First Nations in northern BC occupied a piece of land they said was stolen from them. The Canadian Army surrounded them and laced the perimeter with the landmines Princess Diana and Lloyd Axworthy were trying to ban over Europe at the same frigging time, right? So the dictatorship, and that was all illegal action under the Constitution. Under our Constitution, you cannot dispatch military personnel against our civilian population. They did the same thing at Oka. That was illegal, completely illegal, contrary to the Constitution. Okay? So that was the beginnings of our in-your-face dictatorship. Since the Chrétien government, we have slid into a quiet, polite dictatorship in typical Canadian fashion. You don't see the genocide, but it's there. Security certificates, indefinite detention without knowing the evidence against you. What is that? You don't need to put 60,000 people in a concentration camp. All you need to do is put 5 of them for indefinitely as a message to the rest of us. Okay? That's the same phenomenon. And so this has been going on for a bit, and unfortunately, during this time, the only thing that has saved us from a complete dictatorship is the courts. Under the Harper government, 44 constitutional cases have gone up to the Supreme Court of Canada. The government has lost 43 of them. Okay? So, in the face of this following newsflash, of the 9 judges of the Supreme Court of Canada, only 1 was a Liberal appointment. The other one was a Mulroney appointment, and the other 7 have been Harper appointments. So, his own judges are still... So you understand the perceived depth of this undemocratic government. I am not partisan. I sued Chrétien governments more times than I have Harper's government. A lot of people misunderstand my cases in terms of personalizing them to me. It's not, I don't care which government it is. It's all governments, we have political parties that just have different football jersey colors, I mean, there's not much of a spectrum, right? So we got orange, we got red, and we have le bleu, not to be confused with Québécois bleu bleu. We got the Conservatives. So that's it. So it doesn't matter to me which government it is. If they act unconstitutionally, they have to be made to account. Now, the reason I say, unfortunately, the courts are the only, and I'll finish with this. It's because it's not that they don't try hard or we shouldn't access them. Certainly, I access them because they need to be accessed. They're not the complete and only and best venue for socioeconomic change. As I said before, they're a blunt instrument. They can only do certain things. They can certainly, like in this case, act as a lightning rod to publicize certain issues that people may not be aware of, but they cannot do what needs to be done on a broader scale. Second of all, cases going to the Supreme Court of Canada are extremely expensive. It's a good thing you're sitting down. The average case, and my dear client can attest to, they're not being charged this, but the average case to go to the Supreme Court of Canada is $1.2 to $2 million from the ground up. Okay? Now, there's no way they're paying me that for this. But how many people have that kind of money to go to the Supreme Court, right? 1%. The 1%. That's why you see, that's right. That's why you... And so the other cases depend on the goodwill pro bono services of lawyers, if they know how to take the case up.
After listening to Rocco, my question is, why are we having to sue our government, who use our hard-earned tax dollars to fight us on things that belong to us constitutionally? Or to change things for themselves in a court of law, again, at our expense? I call what we have an elected dictatorship, because we vote for this. If we go to About Canada Now on our website, I'll give you the links to this in the description below. Their story, The Lie, not a country but a corporation. Canada is a constitutional monarchy, a parliamentary democracy with the federal system and strong democratic traditions. As a Commonwealth realm, Queen Elizabeth II is Queen of Canada. Her duties performed by the Governor General at the federal level, by Lieutenant Generals at the provincial level. The Governor General is appointed by the Queen and on the advice of the Prime Minister. So basically, the Prime Minister is the one who appoints the Governor General. Surprisingly, the role of Canada's Prime Minister is defined neither by law nor by written constitution, but is effectively the most powerful role in Canadian politics. The Prime Minister is traditionally the leader of the largest political party in the House of Commons. He or she selects cabinet ministers and allocates the cabinet positions. The Prime Minister and the cabinet have executive power at the federal level of the corporation. If you Google up Crown Corporations of Canada, you can find this on Wikipedia. Canadian Crown corporations are enterprises owned by the Crown, or Queen, in right of Canada. History. Canada's most famous and influential chartered company was the Hudson Bay Company. There's the coat of arms. Down here, list of Canadian Crown corporations, federal. And there's a list of the federal, going down to provincial, and you can see how we're incorporated through the Crown. Of course, our corporate-style constitutional dictatorship didn't start yesterday. Going back to IAQ's website, to the Canadian Fraudulent Constitution History, we have the Constitution Act 1867, also known as the British North American Act, was given by Britain and adopted as our Constitution by the Fathers of Confederation, who were representatives of various provinces. Some had titles of nobility, up to and including our first Prime Minister, Sir John A. Macdonald. This began our constitutional monarchy, and every civil servant, from police officer to member of Queen's Privy Council, swear an oath to our sovereign monarch. I,
Justin P.J. Trudeau, do solemnly and sincerely swear that I shall be a true and faithful servant to Her Majesty Queen Elizabeth II as a member of Her Majesty's Privy Council for Canada. I will, in all things to be treated, debated, and resolved in Privy Council, faithfully, honestly, and truly declare my mind and my opinion. I shall keep secret all matters committed and revealed to me in this capacity, or that shall be secretly treated of in council. Generally, in all things, I shall do as a faithful and true servant ought to do for Her Majesty, so help me God.
Members of the Queen's Privy Council carry the title of nobility, honorable, and comprise of various representatives of various parties and other non-elected individuals. The Queen herself swears and signs an oath. Here it is on her official website. I'm leading up to something important, and I want to bring attention to oaths. The Archbishop, who is representative of the Pope and Vatican, administers a coronation oath. I won't read the whole thing, and I leave you the link for this in the description below, as well as an oath for the Jesuit order of our current Pope. Archbishop, will you solemnly promise and swear to govern the peoples of the United Kingdom of Great Britain and Northern Ireland, Canada, and so on? Now I want you to listen to Rocco speak of the little-known Bank of Canada lawsuit, which to me exemplifies another reason we should be making our own constitution.
So basically, the first part of the challenge to this court action is to force the government to do what it's required to do. It's not as if we're trying to create a new law. The law has never changed since 1938. The government has simply, since 1974, chosen to ignore the law and chosen as a blanket absolute policy never to again give low or interest-free loans to the government of Canada and the provinces. Well, in constitutional terms, that's called abdicating your constitutional duty to govern. You can't do that. What's more atrocious and egregious is the fact that not only have they relinquished or abandoned their constitutional duty to govern, they've handed it over to foreign private interests. And that's a relinquishing of sovereignty. The Honorable Paul Hellyer, some of whom some people in this room know, who's the Dean of the Privy Council of Canada, he was a cabinet minister under the government of Louis Saint Laurent, is also a member of Comer. He calls this giving over Canadian sovereignty over banking to private European bankers treason. Now, while I've never said it's treason, I find it very difficult to argue with Mr. Hellyer over the point.
The reality is the Bank of Canada has, by legislation, the ability to make whatever money is needed, to loan money to the Government of Canada without interest.
The Bank of Canada, as it's stated on its official website, is ultimately owned by the people of Canada and has the power under the Canadian Constitution and the Bank of Canada Act to lend money to the government at no interest. And if there is interest to be charged, it would just come back to the people anyway, since we own the bank.
Yeah, we never should have privatized our debt and turned it over to the private banks. We should have kept it in the hands of Bank of Canada, at least a major part of it, because then we would have been paying interest back to ourselves. And unfortunately, the Liberal government and the Conservative governments both are too close to the banks. The banks wanted the business, and they managed to convince the government to privatize that debt, and of course now they're the ones getting the benefits. That's why you notice that they're still very profitable, even though everyone else is suffering.
And I'm not that knowledgeable on monetary policy, and the Green Party policies have not moved into have not yet adopted the monetary policy that some of our members would like, which is one which would say we should get rid of the loans that we owe commercial banks and transfer that to the Bank of Canada and pay it off with a Bank of Canada loan and then cancel the debt.
Well, they both seem to know a lot about the monetary system to me. And yet last October, in 2008, when the central topic in the federal election was about the economy,
we made a decision to give priority to an issue dominating the news and people's concerns these days, the economy. So there will be an expanded debate on that.
not one single mention was made from any one of the parties about the monetary system, even from the ones who clearly knew about it. But if we go back to the 2006 federal debate, no one would shut up about the $100 million missing from the sponsorship scandal Paul Martin was involved with. But when $160 million goes missing every day, it's no big deal.
The last clips of Elizabeth May and Jack Layton I added to show how the leaders of parties are aware of this treasonous act and yet say nothing at debates or in the House of Commons where it matters, which to me makes them complicit with the treason. These were excerpts from the movie O Canada, bought and sold out land that we have on our website about banking fraud worldwide. You could watch other videos and share them as well to learn more about this. This treasonous act was committed on us in 1974. Right Honorable Pierre Elliott Trudeau was the Prime Minister at the time. You won't find that in the history of the Bank of Canada. It's a little known fact that you'll have a hard time finding out about. We can't trust the mainstream media to say much about this, as Rocco describes here.
How many individuals do you think control the press in Canada, the mainstream press? How many individuals? Take a guess, wild guess.
10.
5. 5, including cabinet, that controls the CBC. Most people here don't know that the CBC is controlled by cabinet. Cabinet can give a secret order and tell the CBC what to do or not to do, and they can't even publicize the got an order.
This case has been going on since 2011, but when it finally hit the light of a TV screen in 2015, months later, Amanda Lang announced she was leaving CBC. I find it funny that Evan Solomon, gets fired shortly after he did a piece of conflicting reports from the RCMP about the Ottawa shooting, which of course started the controversial Bill C-51. Coincidence? I'll leave that with you. Pierre Trudeau, who is the father of our current Prime Minister, Justin Trudeau, is also known for giving us the Constitution Act of 1982, also known as the Charter of Rights and Freedoms. By tacking on a watered-down version of the Canadian Bill of Rights onto the BNA, this package of constitutional amendments was dubbed patriation, a uniquely Canadian term. It included a comprehensive amending formula, the Constitution Act 1982, and the Canadian Charter of Rights and Freedoms. In front of a lot of people that day in Ottawa, he gave the impression to many that the Queen was signing off on Canada and she was no longer our monarch.
Who will breathe life into it? It's in that spirit of faith and of confidence that I join with Canadians everywhere in sharing this day of national achievement. It is in their name, Your Majesty, that I now invite you, the Queen of Canada, to give solemn proclamation to our new Constitution.
She was reaffirmed as our Queen. To explain what I meant by the Charter being a watered-down version of the Bill of Rights, I'll go to our page on our website, Canadian Provincial Bills, Acts, and Charter of Rights. Instead of reading all of this to you, I'm going to go straight to the links below here, which take us to on the Justice Law website, Canadian Charter of Rights and Freedoms, Canadian Bill of Rights. Now, just looking at this, you could see that there's a lot missing in words. But we're going to go to the Bill of Rights. I'm going to read it to you. An act for the recognition and protection of human rights and fundamental freedoms. The Parliament of Canada affirming that the Canadian nation is founded upon principles and acknowledge the supremacy of God and the dignity and worth of the human person and the position of the family in society of free men and free institutions. Affirming also that men and institutions remain free only when freedom is founded upon the respect and moral, spiritual values and the rule of law. And in being desirous of enshrining these principles and the human rights and fundamental freedoms derived from them in the Bill of Rights, which shall reflect and respect of Parliament for this constitutional authority, and which shall ensure the protection of these rights and freedoms in Canada. Therefore, Her Majesty, by and with the advice and consent of the Senate and the House of Commons of Canada, enact as follows. I hereby recognize and declare that in Canada there have existed and shall continue to exist without discrimination by reason of race, national origin, color, religion, or sex, the following human rights and fundamental freedoms, namely, the right of the individual to life, liberty, security of the person, and enjoyment of property, and the right for not to be deprived thereof except by due process of law. Now, if we go back to the Charter, you'll notice that the word human is missing. Whereas Canada is founded upon the principles that recognize the supremacy of God and the rule of law. What law? Who's God? The Canadian Charter of Rights and Freedoms guarantees the rights and freedoms set out in it, subject only to such reasonable limits prescribed by law as can be demonstrably justified in a free and democratic society. Well, we supposedly live in a free democratic society, but they are able to take away our rights. That probably explains why Harper was able to give us Bill C-51. But you'll notice also that the enjoyment of property and security of the person is missing. But we go down here, every citizen of Canada has a right to vote in an election of members of the House of Commons or of a legislative assembly and to be qualified for membership therein. We have a right to vote in their system. But if we choose not to use that right, just like I would choose not to be gay or to own a gun, if we choose not to use our right, do we lose any other right, like freedom of speech? Some people will have you believe that. Anyway, going back to the Charter, go near the bottom. What gives people the right to remove your rights if you choose not to use your right? Application of Charter. This Charter applies to the Parliament and Government of Canada in respect of all matters within the authority of Parliament, including all matters. So who does this really apply to? Does it apply to us? There's a lot of things that need to be defined here. And you have to remember that Pierre Trudeau was a lawyer. Most people think we have natural rights, but we actually have our legal rights. I'll take you to Wikipedia to show you what I mean. Natural and legal rights are two types of rights. Legal rights are those bestowed onto a person by a given legal system. The rights that can be modified, repealed, and restrained by human laws. Natural rights are those not contingent upon laws, customs, or beliefs of any particular culture or government, and therefore universal and inalienable. The rights that cannot be repealed or restrained by human laws. With rights come responsibilities. It's your responsibility to make sure your rights aren't infringed upon and to prove you're deserving of your rights. Your government knows this, and like your rights, they list your responsibilities. By voting for a representative, you're basically advocating your rights and responsibilities to be managed by someone else. I want to take you back to our website, to a page called Why Our Democracy Doesn't Work. If you could see here, vote all you want, the secret government won't change anywhere. That's worth reading as well. But we have videos that show how the first past the post political party system obviously doesn't work for us. But our representative wanted to give us proportional representation, which is more of the same, electing representatives who represent a party line over their constituency, whom elect a leader on our behalf. They become a target for outside influence, who will lobby, which is legal bribery, or even threaten their life or livelihood to get what they want. We have to also remember all parties tend to also want to try to infringe on rights of one segment of society or another, which goes into the divide and conquer aspect of our political party system. Now I'm going to take you back to another page of our website, Sources of Canada's Constitution. Canada has both a written and unwritten constitution. It's also a living document, meaning that it can change over time. This is the written part. Unwritten. The Constitution Act 1867 made no mention of a prime minister, even though Canada has had a prime minister since Confederation. Court rulings, well, that's what Rocco was alluding to at the beginning. This page here is BNA Act 1982, Canada Constitution, farce. Although there is much controversy in regards to Canada's standing and our previous constitution, it's easy to see that they were all based on fraud. We will be adding more information as we go along to show you just how Canada, the USA, and Mexico, basically Turtle Island, were stolen from the Indigenous peoples, how Canada had a silent coup d'etat beginning in 1919 to 1931, and how the Vatican created the Supreme Courts in the USA after it gained its independence, then in Britain and Canada to hold on to their ruling of our souls. the doctrine of discovery, and terra nullius fraud, making their bogus canon laws the supreme law of the land, incognito, and how the lower courts rule under a fictitious legal fiction and dictatorship. Now I'm going to bring you to 1931. I'll have to go back to our other page. Back on Canadian Fraudulent Constitution History, the Statute of Westminster 1931. That's when Britain allowed countries under its dominion to opt out and become their own sovereign nations. Yes, we had a chance to become completely free of the monarchy, but chose, along with other nations, to stay with the United Kingdom and become part of the Commonwealth nations at this time. This still can be contested and was even brought up during the Meech Lake Accord. Now to find out how the Vatican was involved, we go to Who Created Canada on our website. We have several other pages on our website that go into further detail about how Rome legitimized monarchs and heads of state on this planet. Remember how Archbishop, representative of the Pope, who is seen as God personified on earth, ministered the oath Queen Elizabeth took? Rome even legitimized the Magna Carta. Created the Supreme Court. Gave us the birth certificate to start the legal fiction, so even if you don't believe in their God, they still consider to own your soul and give your body, security of your person, to the government who you belong to securitize or monetize you, to be used as a bond for them to act on you and on your behalf in their corporation. We are governed under corporate law, which have origins in maritime or admiralty law. Here's a cartoon to better illustrate that for you.
Ah, the government. It loves you and wants to keep you safe and well. It even wants to make paying taxes, fines, and court costs easier for you. How? Well, you'll need to meet your straw man. He was born the same day you were. He looks like you, has the same name, and lives in your house, but you never knew he existed. You will have even paid his parking tickets or taxes. The worst part? He's been dead from day one. From every birth certificate, a legal personality, or legal fiction, is created with the same name to confuse little old you into thinking it's you. So, there is a human you and a paper you, or as it's commonly known, a straw man. So when it seems like government officials, court clerks, or the police are speaking English, they aren't. They're speaking legalese, designed to make you agree to verbal and written contracts without even knowing about it, all spun from Black's Law Dictionary.
Yes, legalese. The language used by lawyers that is difficult for most people to understand, legal jargon. In Black's Law Dictionary, the word person can also mean a corporation and will be assumed to mean as such unless otherwise specified with an adjective like human or natural person.
Giving over title to the person you register it with? That's right. Whenever you register something with the government, they assume it belongs to them. Registered your car? Super! Now you are the registered keeper of your vehicle, and the government can crush it when you don't pay your, straw man's taxes. Expecting a new bundle of joy? Well then you need to register your little darling with a birth certificate. Then they can start the process all over again and create a new straw man for your little one. Isn't that great? So when Junior grows up, he'll be able to generate revenue just like you have. When you notify on your baby by signing the birth certificate, your child becomes a ward of state, and if the government doesn't like what you're doing, they'll assume it's okay to take the child away, or make new rules for things they don't like. Not enough school? Smacking your child? Shouting too loudly? Then it's off to social services for the little one.
Legal pertains to man-made laws, which are just rules and regulations under the color of law. For example, everything Hitler did was legal, but it wasn't lawful or moral. That's how they were able to prosecute people who committed those crimes against humanity in Nuremberg, where the excuse just following orders was not justifiable in a court of law, which was based on civil or common law. What the Magna Carta is based on, an amplified version of natural law, which are the only laws that can actually be called laws because a natural person is the victim when these laws are broken. Legalities are called acts, statutes, bills, and so on. They act under the color of law, where the artificial person called government or crown is the victim. Back to where I left off on who created Canada, I want to bring attention to a real crime against humanity that's still going on today. The doctrine of discoveries, also known as terra nullius. The doctrine encoded racial ideas that created a hierarchy within humanities that invariably placed European Christian nations in the position of power. If you Google that up, here it explains it better. Papal bulls of the 15th century gave Christian explorers the right to claim lands they discovered and laid claim to those lands for their Christian monarchs. Any land that was not inhabited by Christian was available to be discovered, claimed, and exploited. If the pagan inhabitants could be converted, they might be spared. If not, they would be enslaved or killed. The doctrine of discoveries is a concept of public international law expounded by a United States Supreme Court in a series of decisions, initially in Johnson versus McIntosh. It's a papal bull made into law, still in effect today. It was actually created in 1493, just after 1492 when Christopher Columbus sailed the ocean blue. This launched what's been known as the Age of Discoveries, that legitimized the theft of lands all over the world, which also helped explain things like the residential schools, still in operation today, that helped indoctrinate the native people of Canada to forget their own culture and replace it with their Christian values. This is no less than a cultural genocide perpetrated on them, and what the Truth and Reconciliation Commission is mostly about. It's not like no one has never asked for this to be repealed, but if it was, it could, as this article brings attention to. If the Commission recommends the bull to be rescinded, Sinclair said, it has to weigh the legal implications which could strike at the core of Crown sovereignty over land. Wow. It's looking like their house of cards is beginning to come down, and our true history was hidden from us all. Back on constitutional note, I want to bring attention to something that even a lot of Native people don't even know about their own history, and for good reason. The Great Law of Peace. Back on Wikipedia here, the Great Law of Peace of the Iroquois, or Haudenosaunee, Six Nations, Oneida, Mohawk, Cayuga, Onondaga, the Seneca, and Tuscarora, is the oral constitution whereby the Iroquois Confederacy was bound together. The law was written on wampum belts conceived by Dakinaweda, known as the Great Peacemaker, and his spokesman, Hiawatha. The original five-member nation ratified this constitution near modern-day Victor, New York, with Sixth Nation, the Tuscarora, being added in 1722. The laws were first recorded and transmitted not in written language but by means of wampum symbols that conveyed meaning. In later era, it was translated into English and various accounts exist. The Great Law of Peace is presented as part of the narrative noting laws and ceremonies to be performed at prescribed times. The laws called the Constitution are divided into 117 articles. United Iroquois Nation was symbolized by an eastern white pine tree called Tree of Peace. Each nation or tribe plays a delineated role in the conduct of government. Attempts to date the founding of the Iroquois Confederacy have focused on a reported solar eclipse which scholars identify as one of that occurred in 1451 AD through some debate exists with support of 1142. And if you go further down, influence on the United States Constitution. It had influence on the American Constitution. Wow. So the native people of North America, or as they called it, Turtle Island, had a constitution that predates our own constitution, or even the American Constitution, which it influenced. After their revolution in 1776 against the monarchy of the day. As a side note, I want to bring attention to something that most Americans don't even know about their own constitution, but likely wasn't influenced by the Great Law of Peace. The missing 13th Amendment, no lawyers allowed in public office. I'll be leaving a link for this below. It is because lawyers and attorneys formally registered with the bar, British accredited registry, that they could not be trusted to hold public office in the USA by implicitly pledging their allegiance to an entity of a foreign government. They could not be trusted to act in the best interest of the American Republic or its citizens. Lawyers making laws. The missing 13th Amendment of the Constitution of the United States reads as follows: If any citizen of the United States shall accept, claim, receive, or retain any title of nobility or honor, or shall without the consent of Congress accept and retain any present pension, office, or emolument of any kind whatever from any emperor, king, prince, or foreign power, such person shall cease to be a citizen of the United States, and shall be incapable of holding any office of trust or profit under them, or either of them. President Lincoln changed this, but the Founding Fathers obviously knew how people with titles of nobility could be a conflict of interest in their governance. You can read this for yourself as to why. It's no secret that the governments of the day have made treaties with the native people of Turtle Island and have failed to uphold their end of the bargain. I want to go back to the first little-known treaty called the Two-Row Wampum, between representatives of the 5 nations of the Iroquois Haudenosaunee and representatives of the Dutch government in 1613. The 1613 agreement was recorded by the Haudenosaunee in a wampum belt known as the Two-Row Wampum. This wampum records the meaning of the agreement, which declared peaceful coexistence between the Haudenosaunee and Dutch settlers in the area. The pattern of the belt consists of 2 rows of purple wampum beads against a background of white beads. The purple beads signify the course of 2 vessels, a Haudenosaunee canoe and a European ship, traveling down the river of life parallel but never touching. The 3 white stripes denote peace, respect, and friendship. Haudenosaunee tradition also records the specific meaning of the belt as follows. In form of Haudenosaunee reply to the initial Dutch treaty proposal, "You say you are our father, and I am your son. We say we will not be like father and son, but like brothers." This wampum belt confirms our words. Neither of us will make compulsory laws or interfere in the internal affairs of the other. Neither of us will try to steer the other's vessel. The treaty is considered by Haudenosaunee people to still be in effect. The Haudenosaunee tradition states, "As long as the sun shines upon the earth, that is how our Two-Row Wampum agreement will stand. Second, as long as the water still flows. And third, as long as the grass grows green at certain times of the year. Now we can symbolize this agreement, and it shall be binding forever as long as Mother Earth's still in motion." Well, this treaty kind of flies in your face with our TV programming of cowboys and Indians. We have more on our website about the Two-Row Treaty. Videos sharing the River of Life, the Two-Row Wampum campaign. Great Law, White Root of Peace, the Dish with One Spoon documentary. The story Turtle Island as perceived by Jacob Wawapde. Globalization, theft of Canadian and Indigenous sovereignty. We're in this together. We already started a draft of a constitution called the Two-Row Living Constitution and went as far as defining words and try to define them as we commonly understand them. You'll find our draft of our constitution here on our website and the videos on this drop-down menu. But I want to take you to this article, the most common thing Aboriginal people hear from the average Canadians. The most common thing Aboriginal people hear from average Canadian whenever the subject about atrocities committed against our people is brought up is, "I didn't oppress your people. I didn't have anything to do with it. Why am I responsible? I didn't do anything." That's the point. You didn't do anything. It was your apathy that allowed this policy to continue for generations. Privilege is the ability to not care about a problem that doesn't directly affect you. You may not have done anything, but you still enjoyed all the benefits which have been provided by the government, allowing businesses to take over our lands and push us aside. The electricity from dams built on native lands while our people were displaced. Much of what you possess was made from minerals extracted from mines that were forced onto native lands. This list goes on. It's very extensive. I'll let you finish reading this on your own. But the article goes on and mentions how the First Nations have begun a case against Canada at the UN. The case involves whether Canada has any rights on unceded First Nations land, and Canadian government imposed the Indian Act upon them, residential schools, mass child apprehensions, and forced assimilations. They have also helped themselves to resources on their traditional lands. I can't say I blame them, but going to a higher perceived authority like the UN only gives them more reason to be empowered on a global level, encouraging globalization. The apathy we all have stems from the indoctrination of everyone to not know our true history and not having any way to affect change in our government. Like everyone else, they, like us, will all be cast into globalization, world governance, the new world order, destroying everyone's sovereignty and causing a complete worldwide cultural genocide. In order to protect everyone from globalization, we need to stand together for our national and personal sovereignty. This is why the fundamentals of the Great Law is so important to everyone to know. We need to see each other as human beings, all deserving of natural rights, nothing less, with respect for each other's cultural beliefs. Due to the misconceptions that everyone has regarding the United Nations, and most don't realize that 5 countries actually control it, and now have managed to fabricate a complete global governance of the world. Meanwhile, there's an oligarchy of elitist people who are giving the script to our respective governments to get us to do their illegal actions for them for their personal gain.
The world judged the Iraqi regime was a dangerous aggressor. In the interests of world peace and regional security, the community of nations required Iraq to surrender its offensive arsenal, its chemical and biological weapons, and abandon its nuclear weapons program. Iraq agreed to comply.
The world judged the Iraqi regime to be a dangerous aggressor. In the interests of world peace and regional security, the community of nations expelled Iraq from Kuwait, required Iraq to surrender its offensive arsenal, chemical biological weapons, and to abandon its nuclear weapons program. Iraq agreed to comply. Iraq's continued defiance of the community of nations presents a challenge which must be addressed.
Presents a challenge which must be addressed. It is inherently dangerous
to allow a country such as Iraq
to retain weapons of mass destruction, particularly in the light of
that create more problems for us in the long run. keeping us distracted and divided from doing what we should and could be doing for ourselves. They manufacture terrorism and redefine it to slowly help them impose martial law to further restrict our rights, freedoms, national and personal sovereignty on us all. This oligarchy that I mentioned are the ones that truly run our respective governments. They have their own network of elitist clubs, international commissions, and committees that work in tandem with their own think tanks and institutions that help them indoctrinate us all. They help create or fund various NGOs and foundations with the appearance to help them, but they only steer them in the direction they want us to go, with the illusion of free choice, using the issues they're passionate about as the carrot on a stick to a global governance. Trying to lure us from one set of legal rights to one that seems better, to lead us to greener pastures. Sometimes using famous people to parrot their fix for the problems they created so that they can continue their corporate shell game and tax evasion and use us taxpayers to fund it. When I first started this video, I didn't even want to go as far as to mention these people, so-called elitists, that create our shadow government. But they're in constant search of the right crisis that will bring us to the new world order. They're actually the ones that are behind most of our problems on this planet. They create these problems, they televise them on their corporate media for us to react from them, and they come up with their solution every time. And we pay for this with our lives, our money, and our freedoms. Whenever you talk anti-government or about an oligarchical society that want to control or kill us all, they tend to want to wrap you and whatever you say up in tinfoil and toss out those kind of ideas. They'll tend to go into programmed responses and call you a conspiracy theorist because you're challenging their sense of patriotism and beliefs, and they fall into a state of cognitive dissonance. Or they'll fall onto other pre-programmed responses like, if you don't like it here, move to another country. Or, if you're not for us, then you must be for them, redefining you as a terrorist. All responses of denial. They'll also question your sources, and if you say the internet, don't believe everything you see on the internet, which is true, but at the same time, the wealth of information that you can get on the internet, the very machine that you're probably looking at this from, is better than the spoon-fed information that you're given from the television. I find that most people go through the 5 stages of grief or loss when confronted with information that conflict with their beliefs. Now, being the first, I've given you examples of that. Anger is when you're likely to be called names or ad hominem attacks, insulting off-topic remarks, attempting to discredit you. Bargaining is when people struggle to keep their old belief and work with it. And finally, this depression can set in. It could take years to get people get to acceptance. By then, they may have found others that are aware and share the knowledge and an understanding of it all.